at that point of time with a lot of popular support, who was more or less like a tyrant, having his will going through. But then you stood your ground, fought it up to the Supreme Court level, got it amended, the act amended, as well as the rules got amended. In fact, glad to be associated with you in the process of getting the rules amended when we all worked together in that government. So that's the background to it. But more than this, taking up this same point and a much bigger thing, Swami Dayananda Saraswathi filed a case in Supreme Court. Of course, it's quite a long case, and then it's still pending. Can you just explain that and your role in that? Where does it stand? How do we take it forward to free temples from government control and also make them the centers of socio-religious activities, autonomous activities of supported, protected, promoted by the local society. That's the way the temple system has developed all over the country. So in that context, what is the work going on and what is that you are doing? Kindly you can explain it for the viewers to have an idea of what all this is about.
So before we proceed, I would like to brief the audience a few important events which you have just touched upon. In 1983-84, as you are aware, we were having a united Andhra Pradesh, 34,401 temples, and these temples, topmost was the Tirumala Tirupati Devasthana. N.T. Ramarao wanted to abolish the hereditary system of succession of Archakas. Not only Archakas, office holders, meaning the Nadaswara Vidwan, the barbers, the Portu workers, Birasis, all these people. For that he got the Challakonda Commission. The commission spent 2 years, collected information, but was a biased commission which was having, the report was written before the commission started working, and they gave a report. My father, since 1984, the moment this commission behavior was identified, he was the only person to unite the entire set of people against this commission. But unfortunately, as you know, the brute majority in the assembly prevails. The assembly passed the legislation 87, and it was stayed by the High Court of Andhra Pradesh. It went to Supreme Court because some other group of Archakas filed in Supreme Court under Article 32. So these petitions in High Court were tagged on to the main petition in Supreme Court, and in single stroke of arguments, the legislation was upheld in the Supreme Court. Unfortunately, sir, in the Supreme Court, the matter related to the small temples which we represent, village temples, temples which do not have even 1,000 rupees per annum income, the matter related to them was never heard in the Supreme Court. Historically, even now we tell that one. If the rural temples are closed down, the devotees belonging to the rural areas have no identity, have no chance of worshipping their deities. So my father filed a written submission when the arguments were...
Small interruption here. It's not only not having an opportunity to worship, that also creates a fertile ground
for conversions.
Of other
conversions happening, yes.
And other religions. Because one of the biggest consequences of the small temples being targeted and made dysfunctional is within the village, a set of people who are protecting the dharma are no longer available or not interested, so that created a ground fertile for the conversions as well.
Correct, yes.
Carry on.
So, in 1996, the judgment was delivered upholding the constitutional validity. That is, remove the hereditary system is valid. Then the Supreme Court itself observed my father's written submission. It records in the judgment. It says, over a period of when we were starting to write the judgment, we noticed a petition by Dr. M.V. Rajan. It says that the 24,400 temples will be closed down if this legislation is implemented. However, we did not find time to verify the facts. In fact, if the Supreme Court was really interested in doing justice as per dharma, if you say yato dharmas tato jayaha, if the Supreme Court really wanted to protect the system of worship and the constitution, what it should have done, it should have called up for hearing again. It did not do. Whereas it started legislating. It said, we are appointing 2 committees. One is a welfare committee, when Archaka pay scale. We are not here for pay scale, sir. We don't want to take salaries from government. We are here to serve the Almighty. Who are you? Who is the government to pay salaries to us? We are here, sir, I may be getting emotional when I ask this language. हम लोग थोड़ी भिखारी है, हम भगवान के सेवक है. We are servants of God, not servants of government. And the same Supreme Court, after the committee reports of the Pay Scales Committee and the Welfare Committee came, it had to accept the committee report. Committee report said whatever Soundarajan is telling is true. Supreme Court said, okay, we will leave these temples to fend for themselves. When you want to fend for themselves, means what? Let them go to hell, Bay of Bengal. We don't care. Then why are you there? Are there no rights for the deities? You have first of all demolished. Not demolishing the temple structure. You have demolished the temple system. System of worship you have destroyed. So this went for review, sir. And the review, the Supreme Court said this is the best case suitable for a larger bench. In 2004 the judgment was given. Review 2004. Till 2013 it was not reviewed. We were fighting not only with 1995 onwards, my father started making it a political. He started meeting across the political parties. See, in fact, we have to, just praising him by sentences is not going to give that. You imagine, he went to communist people. He went even to MIM party people. Said, you have to support when it comes for discussion in the assembly. He went and met lot of religious leaders. Jayendra Saraswati Swamiji was there at that time alive. Your Chinnajiyar Swami, in fact, he led one of the agitations in Vijayawada. So, he was a small thread and trying to unite all these people together. So, the amendment happened in 2007 because of the efforts of my father. He could convince Dr. Y.S. Rajshekar Reddy that this legislation has to be amended. And after amending, sir, 2008 it was notified. Till 2015, you became the Chief Secretary of divided Andhra Pradesh. And fortunately, you took it up. That's how the AP side has got the rules implemented. But in Telangana side, still we are fighting. I have met the topmost people. But the endowment officials, sir,
Absolutely.
they are like hippopotamus. Buffalo skin is thinner. Hippopotamus skin is thicker. You cannot penetrate it. You cannot do anything to them. They will find some loophole to say, sir, idoste adaitad sir, adoste idaitad sir, they will tell. See, ultimately, how long can I sit in the minister's chambers? So that is how it is happening, sir. Now, since Dayanand Saraswati, I had to brief this background.
Yeah, this is the background. Now we will discuss the Dayananda.
Dayanand Saraswati, sir. Dayanand Saraswati Swamiji belongs to Coimbatore. He has got an Arsha Vidya Gurukulam. He's a very, very Advaita philosophy. He's a very, very great learned person, Swamiji. He was terribly annoyed with the way temple system in Tamil Nadu is happening. He has been fighting the Dravidian forces. He has been fighting for protecting Sanskrit language. He has been fighting to protect the culture, original Tamil culture, Sangam literature and all. If you see his videos and his interviews, you will start, getting emotional how our legacy has been curtailed and destroyed. How Tamil Nadu has become the great place to get conversions happening in the villages. First of all, they demonized the Brahmins. They said these are all Brahmins are the only cause for all the evils in the society. Then they said temple system, idol worship is to be, destroyed by emotionally by E.V. Ramaswamy Naikar. Then they disconnected Rama from Tamil culture. They disconnected Ganesha from Tamil culture. They did all sorts of nonsense. But he said, unless you protect the temple system and remove it from this Dravidian administration, you cannot protect our culture and religion in Tamil Nadu, the entire country. Because most of the Divya Deshams are in Tamil Nadu. So he went and filed a petition in Supreme Court, which is Swami Dayananda Saraswathi petition. The petition was challenging the endowment legislations of Tamil Nadu, Pondicherry, and that is only basic Pondicherry. Also Andhra Pradesh. At that time it was United Andhra Pradesh because he felt he was actually very close to my father. Challa Kondeya legislation he was not happy. Even Andhra Pradesh was included. In that, the petition, our Prime Minister Modi ji says, Swami Dayananda Saraswati is his Guruji. And he blessed him that you will become the Prime Minister. First thing you have to do when you become the Prime Minister is to see that the endowment acts are amended. Because, sir, as I do not know how many of the people know, endowments comes under concurrent list.
I also didn't know.
Yes, it comes under concurrent list.
Okay.
List 3, item number 28.
Okay.
Concurrent list means what?
They can legislate.
Union government can legislate.
And it overrides.
State government can legislate. Yes. Union government could have legislated. Like they are doing this Waqf. All the Waqf laws, they want to legislate from the center. State Waqf laws will become subordinate. It will be unless it fits into the main.
Absolutely.
They could have done it to the temple system. So as you say, the political will, I feel, is somehow, I do not know why it is lacking. Because of, I do not know political reasons or what reasons, we do not know. But Swami Dayananda Saraswati petition, Supreme Court since 2013, is pending. It has not been heard even once. 2013. So it is pending since
almost all a decade,
more than 12 years, sir. 12 years. So for that, we have filed an impleading application. In fact, your petition is also there in that. As a chief secretary, retired, you say administratively, I may be good, but why should I administer temple system? That was the gist of your this thing. There is a impleading petition by Ahobila Matam, our Acharya, is 46 Peethadipati. He has filed his impleading application. There is a founder trustees association has filed an impleading application. So many, it's now tagged on. It is now the main, it is a main petition which is now going to hear the fundamental rights related to the deities also. Because we have said, because I told you, sir, 1986 to 1995, Supreme Court did not hear the issues related to the deities of 34,000 temples, rural area temples. It did not hear the deities of so many. So I said, when there is issues related to substantial interests of the deity, they should be treated on a separate pedestal. There should be amendment to the rules of the Supreme Court, how they treat the deity cases. So endowment laws means what, sir? It is a deity related temple. Ranganath Swami temple ante, what is the meaning? Srirangam means what? Srirangam temple related to Ranganath Swami. If you say Tirumala Tirupati Devasthanam, if you say, is it related to Tirumala Balaji or not?
Absolutely.
So you cannot isolate Balaji and treat Tirumala Tirupati Devasthanam separately. Why was this great issue related to the Laddu issue became? Because they felt the Laddu was being adulterated, ghee was given as Naivedyam to Balaji. Why the hue and cry happened? Because the deity was being ill-treated by adulteration. Yes, I am just telling, sir, when the Supreme Court said, there is in the great Keshavananda Bharati case, basic structure of the constitution. It said there is a limitation of amending the constitution. The perimeter it fixed for the parliament. You cannot alter the basic structure of the constitution. Fundamental rights, part 3 is a basic structure. If you amend any part of the constitution, if we find that it is against the basic structure of the constitution, we will strike it down.
Absolutely.
Supreme Court has such a vast power. But unfortunately, there is no limitation for interpretive power of the Supreme Court. For example, subject to morality, it is beginning of 25 and 26. Supreme Court has created a doctrine called constitutional morality. This doctrine was created by Supreme Court. Based on constitutional morality doctrine, the Supreme Court says certain practices, whether they are ritualistic or religious practices, or some communities have excommunication, like Dawoodi Bora community, there is an excommunication. Whether they can be brought under constitutional morality and say their excommunication power is invalid, they wanted to do all this kind of thing. But I would say, simple question, Supreme Court has to follow when there is a question of, confusion related to interpretation. They have to go to the Hindi translation. 1975 onwards, we have the Hindi translation. Denomination ki sampradayam. Why are they going behind Oxford dictionary meaning or Cambridge dictionary meaning? What is the meaning of denomination? Denomination is Christian definition of denomination. We don't want that definition. Sir, second part I would like to go and further say, the Shabarimala judgment. Why are you after Shabarimala judgment? People are asking me. They are asking me. The first question, why I am against Shabarimala judgment is, the conclusion of Supreme Court, based on which they said the practice of excluding women of 10 years to 50 years from entering the sanctum or worship at Shabarimala, is the deity does not have fundamental rights in the country. Which is a very, very unfortunate kind of conclusion. Now, if that is the case, Padmanabha Swami was a ruler in when the constitution was enacted, before getting merged with the Union of India. there was a covenant signed by the Padmanabha Dasas, that is the royal family, with Sardar Patel. He went and negotiated the merger. So they said, we will not take the oath as Raj Pramukh. We are not Raj Pramukh. Our deity is the supreme. Who are we? So, status of Padmanabha Swami, he is a deity. He is a deity, sir. Curzon, we discussed during our last Telugu interview, Lord Curzon, who bifurcated in 1905, Bangladesh. First bifurcation, he did, East Bengal, he created. Curzon was a person who sowed the seeds of bifurcation in this country. And that Curzon goes to Kerala. When Chitra Tirunal Balarama Varma takes from this Lord Curzon in a chariot, they pass through the Ananta Padmanabha Swami temple. They, on the road, you can see that main road, the temple, Gopuram is visible. The moment they near that Gopuram, the ruler, the king, that is, he is the dasa of deity, stands up and with folded hands stands up. This Curzon is on his, mocking at him. He is saying, Maharaja, Your Excellency, what is the meaning of that posture which you did just now? He says, I am bowing to my king, who is almighty. He is the king of this land. He is the Padmanabha Swami. Lord Curzon remarks, oh, this is the place where lazy people are fed. Free food, free meals. And our Balaram Varma is shocked by that statement. He feels insulted. Evening, they were supposed to have a welcome meeting or a banquet for the Viceroy, Lord Curzon. King says, the Balarama Varma says, I am not going to come and participate in any function which is going to officiate. And Curzon says, I will deprive you of your rulership. You may do anything. I am not going to come and participate. They are waiting, all the guests are waiting, and our Padmanabha Dasa, Balaram Varma is not coming. Then they ask this Curzon, sir, please take back your words, which is insulting to the deity. Otherwise, our Balaram Varma family, they cannot take any insult to their deity. So he apologizes publicly. Then our Chitra Tirunal Balarama Varma comes and joins. Such is a legacy, sir. And such is a legacy, and the Supreme Court says the deity does not have any fundamental rights. Unfortunate, sir. Second, I would like to tell. This Prince of Arcot. Have you heard about the Prince of Arcot? The Prince of Arcot is the Nawabs.
Yeah, no, that I know. Yes.
These Nawabs.
And Tirupati comes under that.
Yes. Prince of Arcot is given a same kind of a ruler status. When the 26th Amendment happened, they removed all the rulers, they made them citizens and all. The Prince of Arcot is not given, is given a separate treatment. They say, because he has been given the title Prince of Arcot by the Queen. And what is our nonsense, sir? You are recognizing and honoring the title given by the British Queen, but not honoring the same covenant entered by Sardar Patel. For merging, you give the ruler status to the deity. That is the fundamental question we are asking for so many years. So, in 22nd January 1947, sir, let us summarize because it's becoming longer.
No, it doesn't matter. Clarity is more important.
Now, now what is the constitution, basis of the constitution? The Constituent Assembly debates and the objectives resolution passed in 1947, January 22nd. The objective resolution was moved by Pandit Jawaharlal Nehru before partition. The constitution in unpartitioned land before partition said if it partition is happening, that side or this side, both will have a constitution which will protect the minority, freedom of worship, belief and faith. That is the objective resolution. So they went off Pakistan. You know what happened there? There is no minority today. It's an Islamic state they have made. Here, we also are behaving the same way. This is number one. January 22nd, Ramalalla reincarnation in Ayodhya happened. Lot of people were telling why January 22nd. When our Honorable Prime Minister went and inaugurated, before elections, lot of people said it's politically motivated date. He wants to win again election showing Rama there. We were the only ones, sir. My father said, please tell these people January 22nd is because of a reason. 22nd January, Sri Rama himself reminding us that I am the Ramarajya Sthapana in the constitution reenactment on 22nd January. Because part 3, what they had said, sir? 1950, if you see part 3, Sri Rama, Lakshmana and Sita Devi returning to Ayodhya is a picture there in the constitution. Then they made it secular. Now our Ramarajya Punasthapana is on January 22nd, 2024. Now we are telling the pious purpose of incarnation of Sri Rama is there in the oath in the name of God. Every, sir, constitutional period, because you have been chief secretary, many people you have seen before you, so many people take oath in the name of God. This is where our impleading application is pending in the Dayananda Saraswathi petition. We are asking straightforward question to the Supreme Court. Is there a need to amend the rules in the Supreme Court so that you treat God as God? Oath in the name of God, do you give him importance? Because Supreme Court has got a way of handling death convict cases. Suppose somebody is convicted to death. What do? First you give him review, freedom to take review petition. If the review is dismissed, he is gone curative, and then he has got a chance to go for a mercy petition. Till that time, the execution is not happening. Why don't you treat 1,000 times more importantly cases which have substantial deity interest? That is a fundamental question we are raising, sir. And this is common man. I didn't want to use legal terminology here. Simple, common man question. This is what is there in our bunch of applications pending before the petitions committee in Andhra Pradesh, because the Honorable Deputy Speaker, Sri Rangarajan Krishna Rao, he was the one in 2021 in the Parliament. He spoke in the interest of deities' rights, fundamental rights to the deities. First time Parliament, somebody spoke for the deity is Rangarajan Krishna Rao. We will go on record. Then now he has become Deputy Speaker. So through one MLA, he has filed a petitions committee asking him to refer it to the Attorney General and Advocate General to go and ask the Supreme Court, when substantial deity interest cases come, should you not amend the rules so that they give proper hearing? That's what we are asking, sir.
And where does it stand, this Swami Dayananda Saraswathi petition? Sir. When will it get a disposal? What is your expectations around what time? Because it's almost all 12 years since it's there languishing in the court.
Through you, I would like to request the union government, because it is in a concurrent list. You yourself have to depute the Attorney General because he is an officer of the court. And like you have Special Marriages Act, you had day-to-day hearing, which was not needed for this country. Special Marriages Act, ultimately what did you do? You said it is up to the legislator or parliament to enact legislation. Everybody knew that. You spent so many hours of the Supreme Court, voluminous papers were filed, arguments were heard, and then ultimately what was the conclusion? Special Marriage Act, we are not in a position to give any judgment. Let us leave it to the political bosses to take a educated decision. That's what is here. We this pending the last 12 years, sir, and our Honorable Prime Minister's Guruji's petition, Swami Dayananda Saraswathi, is a person who blessed our Honorable Prime Minister to become Prime Minister. I remember, sir, September 2014, the moment he took up, he became the Prime Minister. Swami Dayananda Saraswathi, my father, and Subramanya Swami, all three of them in the same dais. He was appreciative of my father's efforts. He was in a wheelchair. He said, if this case is decided in favor of the temple system, that will be the future of this country. And he showed the thumbs up like this. And I request through you, sir, IYR Talks, somebody sees this video, let them go and brief the Honorable Prime Minister and the Cabinet. They have to depute the Attorney General so that this case is taken up. Day-to-day hearing happens. How Tamil Nadu has destroyed the temple system. And it has become a disease in the southern states. So my humble submission is this.
And incidentally, it is only the southern states where you have the Endowments Act.
Correct.
It is something specific to Madras Presidency.
Correct.
Enacted by the British in 1933.
Correct.
I mean, other states are spared of this. Yes. So this is a peculiar problem. In fact, Telangana didn't have it. Telangana got it as a legacy of United Andhra Pradesh.
Telangana got it as a curse. I won't say legacy. Hyderabad endowments regulation was a super regulation.